Mrs. Roberts, can you please call the matter? You're on mute, Mrs. Thomas Roberts.
Sorry, President. Caribbean Court of Justice, original jurisdiction, hearing of the originating application in AGOJ number 1 of 2021 between Ellis Richards, Medical Benefits Board, Spencer Thomas, and others, and the state of Trinidad and Tobago. The members of this morning's panel are Mr. Justice Saunders, President and the presiding judge.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnathli.
Good morning, everyone.
Mr. Justice Burgess.
Good morning, Counsel.
And Mr. Justice Jamadar.
Good morning.
May we have the appearances, please? Thank you.
Although it's not my application, I will go first as the claimants, and good morning, Your Honours. I appear together with Senior Advocate Attorney Dr. Kenny Anthony, and with the following Advocate Attorneys at Law, Mr. Gregory Pantin, Mr. Rob Strang, Professor Matthew Happold, and Mr. George Kernan, and we are instructed by the instructing attorney at law, Miguel Vasquez. Thank you.
Yes, good morning again.
Your Honor, should it please you, Mrs. Deborah Peake leads me tomorrow Tuesday for the defendant, the state of Trinidad and Tobago. We are instructed by Mr. Brent James and Mr. Murvani Oja Maraj of the Chief State Solicitor's Department.
Yes, and good morning to you again. I know that Mr. Justice Jamadar is in a location where the internet may be a little spotty. And so from time to time, he may turn off his video. But if he is not with us at any time, then I will stop the proceedings. Speaker, are you ready to proceed?
I am, Your Honor. Good morning.
Yes, good morning.
In determining the two preliminary issues which have been ordered to be tried pursuant to this court's order of the 15th of June 2022, we start by inviting Your Honors to ask the simple and common sense question: what is this claim before the court all about? The claimants, non-nationals of Trinidad and Tobago, are challenging the actions of the state of Trinidad and Tobago to bail out or provide financial assistance to certain subsidiaries of CLF, which is CL Financial Limited, a local company in 2009 and thereafter, as being discriminatory. That is their allegation. In the originating application at paragraph 50, the claimants refer to it as the BA Rescue Plan. Under the caption Summary of the Claim at paragraph 1 and continuing of the originating application, you'll find it at page 3. This is how the claimants themselves summarize their claim. Paragraph 1. This claim arises out of the financial collapse in 2009 of the Trinidadian conglomerate CL Financial and the decision of the government of Trinidad and Tobago to rescue certain of CLF's insurance and financial subsidiaries, and in particular to protect the funds of their policyholders and depositors. At paragraph 2, they say the claimants were all policyholders in CLF's insurance subsidiary, British American Insurance Company Limited, which we shall call BACO. They were not offered the protection that the government gave to policyholders in CLF's other insurance subsidiaries, Colonial Life Insurance Company Limited, CLICO, and British American Insurance Company Trinidad Limited, which we shall refer to in these proceedings as BAT. At paragraph 4, they say the claimants claim that the actions of the government in preferring the policyholders of BAT over those of BACO were discriminatory in breach of the Revised Treaty of Chaguaramas. The government treated the claimants differently from the policyholders of BAT on the basis of their nationality, in contravention of Articles 7, 6, and 184 of the treaty. At paragraph 9, they say the claimant's claim is based on the fact that the government, acting in part through the Central Bank of Trinidad and Tobago, intervened to save the customers and policyholders of BAT and not those of BACO. In other words, they say the Trinidadian clients are British American, but not its clients in the Eastern Caribbean. Or they distinguish between BAT and BACO, where the only real distinction between those entities was that BAT had Trinidadian clients and BACO did not. At paragraph 10, they say the government's intervention and rescue of British American policyholders was discriminatory on the ground of nationality in breach of Article 7 of the treaty, which prohibits such discrimination. The government's intervention came within the scope of the application of the treaty because it concerned the cross-border provision of services under Article 36(4) and the correlative right of consumers to receive such services, and it concerned a measure taken by a member state to provide redress for consumers within the scope of Article 184(1)(g). 11, they say the government did not merely omit to include them in its rescue of policyholders, but took active steps which damaged their interests. And at paragraph 12, the government's actions were calculated to exclude non-Trinidad and Tobago policyholders from the rescue and to benefit Trinidadian policyholders at the expense of non-Trinidadian policyholders. Accordingly, these were discriminatory restrictions imposed on the rights of BACO policyholders, contrary to Article 36(1) of the treaty, and they amounted to a breach of Article 7. The pleadings tell us, Your Honors, that the bailout entailed liquidity support or an injection of funds in identified subsidiaries of CLF, that is CLICO, BAT, and CLICO Investment Bank. And we invite the court in this regard to look at the MOU, the Memorandum of Understanding, signed by the government of Trinidad and Tobago and CLF, which you will find at Annexure F to the originating application at pages 740 to 744 of the record, as well as paragraphs 44A and 58 of the originating application. It also included an assumption of control of CLICO and BAT, which are entities regulated by the Central Bank of Trinidad and Tobago. You will find that reference at paragraphs 9, 40, and 66 of the originating application, and the state's purchase of rights of a number of policyholders of CLICO and BAT, totaling some TT $12.6 billion, and you will find this reference at paragraphs 45, 46, and 58 of the originating application. Now, as a regional court sitting as part of the complex international law landscape, we know that this court doesn't wear blinkers and will be well aware that the matter of bailouts or the grant of financial assistance by governments to financially strapped institutions which pose a threat to the stability of the economy is nothing unique to Trinidad and Tobago. In fact, the same occurred, as we all know, in the UK and Europe and the US following the 2007-2008 subprime mortgage crisis, with the UK at that time bailing out banks such as Northern Rock and the EU having to actually bail out countries such as Greece, Cyprus, and Portugal, where those governments were unable to service their debts or assist indebted banks. In each country, just like in Trinidad and Tobago, there was legislation enacted to give effect to the bailout or to grant a financial assistance to avoid economic stability of the country. We have put before the court, Your Honors, the position of Japan, which was taken even in advance of the crisis in 2007-2008, where in 2002, at the WTO level, you will find this at tab 15 of our bundle at page 2168, measures taken by that government to help banks and life insurance companies become more profitable were regarded as services supplied in the exercise of governmental authority, a phrase that we will become very familiar with shortly. And it was carved out of the General Agreement of Trade and Services and the Annex on Financial Services. So the fact that contracting parties to free trade agreements undertake such activities and then maintain that they fall outside the scope of application of free trade agreements is not at all unusual. So for the purpose of determining the two preliminary issues, we are not looking at the claim made by the claimants under Article 184(1)(g), which does not fall within Chapter 3, and in particular, the focus of today's hearing, which is Article 30. Insofar we see as the claim under Article 7, which deals with non-discrimination, is concerned, in order for that article to be invoked successfully, we ask the court to note two things. One, Article 7 speaks of discrimination on the grounds of nationality only. And secondly, and more importantly, the acts complained of must be within the scope of the application of the treaty, using the language of Article 30. So that if we are right, Your Honors, in our analysis of the claim and our construction of Article 30, then Article 7 cannot be prayed in aid by the claimants in respect of any alleged discrimination on the ground of nationality only for alleged breaches of Articles 36, 37, and 38, which all form part of Chapter 3. As on our construction of the bailout or rescue, we say that that is the quintessential exercise of government authority, which is an activity conducted by a public entity using the words of Article 30, with a guarantee or using the financial resources of the government within the meaning of Article 33, and it is therefore excluded from the operation of Chapter 3 altogether by Article 32. So let's turn now to Article 30, because the proper interpretation of this article is at the heart of the preliminary issues which this court is about to determine. Happily, the principles of treaty interpretation are not in dispute between the parties. And for the purposes of determining the preliminary issues, permit us just to summarize for the court the most important of these. The first, speaking specifically of the RTC, this court has said in the Roca Distribution and State of Trinidad and Tobago 2022 case, which you will find at tab 3 of the claimant's bundle. Specifically, this court has said, as with all treaties, the RTC must be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of their object and purpose. And then there's a reference to Article 31 of the Vienna Convention on the Law of Treaties. You will find that reference at paragraph 23 of that case at page 2298 of the record. The second principle that we wish to draw to the court's attention is a statement made in the Competence of General Assembly regarding admission to the UN Advisory Opinion, which is tab 3 of our bundle, which you will find at page 1897, where it is said, the first duty of a tribunal, which is called upon to interpret and apply the provisions of a treaty, is to endeavor to give effect to them in their natural and ordinary meaning in the context in which they occur. If the relevant words in their natural and ordinary meaning make sense in their context, that is the end of the matter. The third reference is from the text Oppenheim's International Law 9th edition at paragraph 629, page 1267 of the, page 1872 of the record, where it is said, the purpose of interpreting a treaty is to establish the meaning of the text, which the parties must be taken to have intended it to bear in relation to the circumstances with reference to which the question of interpretation has arisen. The fourth is a reference to this court's decision in TCL and Cooperative Republic of Guyana, 2009, which you will find at page 1874 of the record. That's tab 2 of our bundle, where the court said, invariably, a treaty's provisions reflect a compromise of conflicting national interests and divergent perspectives. And the court goes on, the preamble of the treaty is an important part of its context for the purposes of interpretation. Through the preamble, one is made aware of the goals of the states parties and of the statements of principle by which they propose to be guided. The fifth reference that we think is apposite is to Article 31.4 of the Vienna Convention, which says, a special meaning shall be given to a term if it is established that the parties so intended. And of course, here we are dealing with a special meaning for the purpose of Article 30 and for the purpose of Chapter 3. The sixth and final reference is to the House of Lords case of European Roma Rights against Immigration Officer, which is tab 6 of our bundle at page 1993, where you will see Lord Bingham saying, however generous and purposive its approach to interpretation, the court's task remains one of interpreting the written document to which the contracting parties have committed themselves. It must interpret what they have agreed. It has no warrant to give effect to what they might, or in an ideal word would, or can I add respectfully, what the claimants suggest have agreed. This would violate the rule also expressed in Article 31(1) of the Vienna Convention that a treaty should be interpreted in accordance with the ordinary meaning to be given to the terms of the treaty in their context. And Lord Bingham continues, quoting from the Privy Council decision of Brown and Scott, where it was said, it is generally to be assumed that parties have included the terms which they wish to include and on which they were able to agree, omitting other terms which they did not wish to include or on which they were not able to agree. And caution is needed, and this is a quotation, if the risk is to be averted that the contracting parties may, by judicial interpretation, become bound by obligations which they did not expressly accept and might not have been willing to accept. So those statements of treaty interpretation we commend to this court, and we know the court is well familiar with them, but we think it is useful just to have that as the backdrop against which our submissions will follow. So we turn now to Article 30, which is the focus of today's hearing. And if you look at that article, you will see that, as the heading tells us, the subject matter of the article is the scope of the application of Chapter 3, which deals with the right to establishment, the right to provide services, and the right of movement, including the movement of capital in the community. Now, if we pause there, because we know the court has read all of the papers, it's difficult indeed to see how the bailout of CLICO and BAT can fit into any of the provisions of Chapter 3, and in particular Articles 36, 37, and 38, which deal with the right to provide services and which are the articles invoked by the claimants in Chapter 3. But before we can even get to Articles 36, 37, and 38, the court has to be satisfied that the acts, or to use the language of Article 30, the activities being challenged by the claimants are not excluded from the operation of Chapter 3, and therefore Articles 36, 37, and 38. So looking at Article 30, 31 tells us what the provisions of Chapter 3 apply to, and there's no issue with that. And then immediately following sub-article 1, we have sub-article 2, which tells us activities in a member state, so in Trinidad and Tobago, involving the exercise of governmental authority shall, insofar as that member state, that is Trinidad and Tobago, is concerned, be excluded from the operations of this chapter. In other words, when one comes to ask oneself the question, what is covered by Chapter 3, or what activities of a member state fall within the purview or operation of Chapter 3, that is, what activities are prima facie justiciable under Chapter 3, on the plain language of Article 32, one has to exclude activities of the state which involve the exercise of governmental authority, as that term is defined in Article 33. That seems pretty clear to anyone reading the language used. And the framers of the treaty, Your Honors, weren't content to leave that expression in Article 32 open to guesswork or interpretation by individual member states. They went further in Article 33 to define precisely what they mean by the expression used in 2, which is activities involving the exercise of governmental authority. So we have here a specific meaning for a specific chapter of the treaty. In our respectful submission, the claimants cannot simply ignore the express wording of Article 33 as they have sought to do in their submissions. And we say to invite this court to ignore the clear words of the treaty is to invite the court to fall into error and to fall afoul of Article 31(4) of the Vienna Convention. Using the language of Article 31(4) of the Vienna Convention, the special meaning given to the term exercise of governmental authority cannot be brushed aside in favor of some other meaning that is more convenient to a party or parties. According to the...
Ms. Peak, so am I understanding you to be saying that the court should interpret Article 30 in that plain and literal manner? And if so, would that mean that activities involving the exercise of governmental power, which are neither commercial nor in competition with other economic enterprises, may be undertaken with impunity, even if their consequence is to undermine the obligations Chapter 3 imposes on all states?
Well, Your Honor, I don't like the categorization with impunity, but what I do see is that the framers were very clear in the language which they used, and they went further to say, well, we don't only mean activities neither on a commercial basis nor in competition with one or more economic enterprises, but they give a list. So therefore, as in the Myrie case, the court was not dissuaded from giving an interpretation of the treaty which met the justice of the case and did not allow the government of Barbados to disregard the rights of the community national with impunity. But for the purposes of this application, what we are inviting the court to do is to interpret the treaty to the facts of this case. We're not asking the court to give an interpretation which is broader and will bind parties forever and ever. But where we're dealing with a situation in which the framers of the treaty have expressly provided for the situation which is being challenged here, then we say whatever one's personal views may be, and to use the language of Lord Bingham, there is no warrant for picking an interpretation which does not meet the language used by the treaty makers. So, and you will see that my learned friends invoke that argument by saying, well, the dead letter argument, the submission that we make carries the parties too far, the court too far, and therefore we are denuding Chapter 3 of any effect. We say no. Our submission must be confined to the facts of this case, and we must, as we respectfully submit, the court must interpret the treaty to the facts of this case in determining in which way it will rule on the preliminary submission. But we are not inviting the court to see that now and forever states can disregard with impunity the rights of nationals. No, that is not what our case is. May I continue, Your Honor?
Yes, please.
Thank you. So we say, according to the framers, the special meaning given to the expression activities involving the exercise of governmental authority for the purpose of this chapter only is activities conducted neither on a commercial basis nor in competition with one or more economic enterprises. And then they list a number of activities which fall within that description of being conducted neither on a commercial basis nor in competition with one or other economic enterprises. And of course, D of that list fits fairly and squarely into the fact situation, which is the subject of challenge in these proceedings. That is, activities conducted by a public entity, that is the state, for the account of or with the guarantee or using financial resources of the government. So where court is faced with a provision, whether it's a statutory provision or provision of a treaty in this case, which covers precisely the ground which is the subject of the challenge, no matter what the court's feelings may be as to whether, in fact, the interpretation or the conclusion we arrive at in this case is what, they would have wanted to be contained in the treaty, is really not to the point, because the court's function is to interpret the treaty and apply that interpretation to the fact situation that is before it. And that is the limit of what we are inviting the court to do in this case. We're not asking the court, as my learned friends have suggested, that the court in Mary somehow defined Article 30 for all time. No. And the court will not in this case be defining Article 30 for all time either. The court will be construing Article 30 in the context of the facts of this particular case without prejudice to whatever construction they may come to on a different fact situation in a different case. We ask the court to note.
Mrs. Speak.
Yes, Your Honor.
Yeah, I wondered if you could just expand a little bit more. I think you have done it already, but just perhaps a little more on the significance of what is stated in Article 30, paragraph 3, when it refers to the exercise of governmental authority, meaning activities conducted neither on a commercial basis nor in competition with one or more economic enterprises, because there is a provision, as you're aware, in the treaty, which speaks to the idea of the CSME being private sector driven. And in that context, I'm just wondering if you have any thoughts on the significance of defining governmental activities in a way which excludes governmental involvement in activities on a commercial basis or in competition with economic enterprises.
So that the context, of course, is a free trade treaty, a treaty dealing with trade among states of the CARICOM region. And therefore, that is the context in which I think the framers of the treaty sought to carve out in this provision activities which are inherently governmental in nature rather than those which have to do with intervening in trade or trade between states or nationals of states. And I think that assists in kind of putting it into context. And we have in our submissions, you will recall, set out those provisions of the preamble which emphasize what this treaty is all about. So this treaty is all about encouraging trade among member states and facilitating those activities in the interest of developing, a community that is trading, that will compete with other trading blocs in the world. And therefore, that is the context in which we believe that the intention was to say, well, look, once you're not doing any activity that is of that nature, in keeping with what the intent of this treaty is all about, that those types of activities should be included. And if you look at the list of examples given in 33, I think it emphasizes the kinds of activities which the treaty makers thought was important to carve out of it, things which are inherently part of the sovereignty of the state and therefore have nothing to do with, enhancing or obstructing free trade among member states.
Yes, because I was a bit puzzled by the comment of counsel opposite, which no doubt will come to in due course, which suggested that if we gave the interpretation to Article 30 that you allege, then that would rob and denude, I think was your word, the article of any vitality or any life. But from what you're saying, it seems to me that once this is private sector activity which is taking place, the government is involved in a commercial way or on a competitive basis with those entities, then the government comes under the discipline of the regime.
That is correct.
But if it does not involve commercial activities or competition with others, then it doesn't interfere with the private sector driven nature of the CSMA. Am I right?
That is correct, Your Honor, and we're very grateful for that assistance in focusing us on exactly what was the intention in excluding these types of activities. Much obliged. We asked the court.
Just before you resume, just to summarize it, and what makes that so is that this is a bailout. That's a short point. This is simply a bailout, and that is why it is governmental in nature, according to
Correct. There's nothing commercial about it. This is using the largesse of the state to assist companies, which if they were allowed to go under, would destabilize the economy. That is what it is all about. It has nothing to do with intervening in the insurance sector, benefiting one company over another company operating in the insurance sector, nothing like that.
Okay, thank you.
Much obliged. We asked the court to note that contrary to the claimant's submissions, which notwithstanding their protestations do contain statements which support the defendant's interpretation, Article 30 does not speak of or use language such as, and I'm quoting from their submissions, underlying activity or nature of the underlying activity, field of activity, area of activity, regulated activity, or activity of regulation or intervention, in the special meaning given to the term activities involving this exercise of governmental authority for the purpose of Chapter 3. And for these purposes, we invite the court to look at my learned friend's submissions at paragraphs 8 and 34, which you will find at pages 2203 and 2210, and paragraphs 10, 12, and 21 to 23 of the skeletal argument filed yesterday, which you will find at pages 2548, 2549, 2551, 2552, 2556. In our respectful submission, this is an impermissible attempt by my learned friends to rewrite the treaty. The article simply refers to activities, and there is a special meaning given to that expression in Article 30. In our submission, there can be no doubt that the activities of the state in this bailout or rescue, or providing liquidity support to CLICO and BAT, and purchasing the rights of their policyholders involving the use of state funds, fall expressly within the meaning of Article 33D. Similarly, there can be no doubt that the assumption of control of CLICO and BAT by the central bank, qua regulator, and taking control of CLF's assets in exchange for the liquidity support provided were activities conducted, and to use the words of Article 33, neither on a commercial basis nor in competition with one or more economic enterprises. Therefore, we submit this is a plain case in which Article 32 and Article 33 apply, no matter how inconvenient it may be to the claimants. In the ECJ case of Thyssen, which you will find at tab 6 of our bundle at page 1864, the Insurance Inspectorate of Belgium, similar to the central bank in this case, had the task of supervising the application of the relevant law and its implementing regulations, and had the power to intervene directly in the management of insurance undertakings. There was no dispute in that case that the Insurance Inspectorate was exercising official authority, which is the language used in Article 51 of the Treaty on the Functioning of the European Union, which is a provision similar to our 32, but without the benefit of a definition section, such as we have in Article 33. You will see that at paragraph 11 of the case at page 2195 of the record. In Thyssen, the question the court had to determine was whether the holders of the office of approved commissioner exercised official authority within the meaning of what is now Article 51 of the treaty or the functioning of the EU. These office holders were freely appointed by insurance companies from a pool of commissioners approved by the Insurance Inspectorate. As you will see at paragraphs 17 to 21 of the judgment, the ECJ looked at the specific activities undertaken by the office holder in the course of his employment to arrive at its decision. But there was no carte blanche approach, as the claimants commented this court, that because the approved commissioner worked in the insurance sector or that area or field of activity, Article 51 did not apply. Insofar as the claimants in their submission seek to argue that the Myrie case, which is tab 1 of their bundle at page 2221, interpreted Article 30 narrowly, and it is that narrow interpretation which this court should place upon it, we submit that this court's interpretation of Article 30 in Myrie is only a starting point for the task on which the court must embark in this case. The facts of Myrie, as we know, were vastly different to the present case, and the court in that case was not called upon and did not purport to interpret the article beyond the facts of that case. As the claimants accept that paragraph 25 of their submissions and the footnote at page 228 of the record, the quotations from the Myrie judgment that they have cited are taken from the ECJ case of the Commission against Belgium, which was dealing with a different article. They were dealing with Article 48.4 of the now repealed EEC Treaty, which stated that freedom of movement of workers did not apply to employment in the public service. This case, as we know, has nothing to do with employment in the public service, but this court did recognize in Myrie, and the claimants properly accept, that the purpose of the subarticles in 30 is to preserve certain aspects of member states' sovereignty, and it is settled law that in interpreting and applying the treaty, each case must turn on its own facts. We submit that there is no higher attribute of state sovereignty than for a state to decide what are the causes that it wishes to spend public finances gratuitously on, or to give financial assistance, which has nothing to do with the free market or trade in goods and services, which is the subject matter of the treaty. And of course, we know this happens routinely in the global context, when more developed countries give aid to developing countries. Indeed, I don't know if we could survive without that kind of contribution. But there is no suggestion there that a sovereign country cannot choose to whom or to which country it wishes to give financial aid. Contrary to what the claimants suggest in their submission, we do not say that it is only our reading of Article 32 and 33 which permits states to adopt macroeconomic and political solutions. In our principal submissions, we have in fact sorry, are you hearing me, Honors?
Yes, but
Yes,
there's feedback somewhere.
Sorry, we have in fact made the opposite point, that the court cannot lose sight of the fact that the treaty is primarily a treaty intended to operationalize, facilitate, and govern free trade within a customs union. Unlike the EU context, CARICOM is not a currency union, and it is not a supranational legal order where member states have ceded legislative competence. The dicta cited by my learned friends from the Wimbledon and Van Gendel and Lewis cases recognize that by entering into treaty arrangements, a sovereign state such as Trinidad and Tobago limits its sovereignty only in limited fields, that is, fields that it chooses. And on a reading of Article 30, and in particular Article 32 and 33, the state of Trinidad and Tobago, like other member states, did not limit its sovereignty and its right to undertake activities which are conducted neither on a commercial basis nor in competition with one or more economic enterprises, including activities such as what is this case is all about, which involve the guarantee or use of financial resources for the bailout of financial institutions. When one looks at Articles 30, 225, and 226, it is clear, we see, that where contracting parties to the treaty wish to carve out certain matters, they did so expressly. And similarly, where they sought to provide for restrictions to be imposed on certain rights conferred by the treaty, such as in Articles 43, 47, and 48. They did so. The fact that Articles 43, 47, and 48 exist doesn't mean, we see, that member states ceded their competence to take macroeconomic and political measures, such as those in issue in this case, to CARICOM. We say that Articles 30 and 47 are not mutually exclusive. One, that is Article 30, delimits the scope of Article 3 and the contents of the rights conferred by that chapter. And the other, 47, provides for temporary restrictions or derogations from rights. Insofar as the claimants now seek to rely on Article 47 to support their construction of Article 30, we say that on the claimant's own pleading and on the undisputed facts, Article 47 is of no application whatsoever to this case. First, we say Article 47(1) applies where the exercise of rights granted under Chapter 3 creates serious difficulties in any sector of the economy of a member state or occasions economic hardships in the region of the community. In that case, a member state adversely affected may apply such restrictions on the exercise of the rights as it considers appropriate. But on the facts we see pleaded by the claimants, the exercise of rights of free movement, establishment, or services is not what created serious difficulties in Trinidad and Tobago at the time of the bailout. In fact, this is made clear by paragraphs 1, 29, and 34 to 54 of the claimant's originating application. It is not in dispute. CLF was a Trinidadian company, and we turn only to paragraph 29 of the originating application at page 11 to see how they put it. In 2009, they say CLF and its financial subsidiaries collapsed into insolvency. In January of that year, faced by a run of withdrawals from depositors and policyholders, which it was unable to pay, CLF approached the government for financial assistance. So we say there is nothing before the court which is capable of establishing that the difficulties experienced by CLF and their subsidiaries and the request for assistance from the state stemmed from the exercise of rights of free movement, establishment, or the provision of services, and therefore Article 47 is of no application. The second reason we see is that any suggestion that the state failed to comply with Article 47 is circular, because Article 47 is located, guess where, in Chapter 3 of the RTC. And our position is that the bailout activities of the state are accepted from Chapter 3 by virtue of Articles 32 and 33. That is, that it had nothing to do with the rights of free movement, establishment, or the provision of services within that chapter. And the claimants at paragraph 37 of their reply have accepted that the government's actions did not involve the provision of services within the meaning of Articles 36, 37, and 38. So it follows, we see, that there was no obligation on the state of Trinidad and Tobago to notify CARICOM of the steps it took as part of the bailout. And notably, at no time has CARICOM ever suggested that the state ought to have notified it under Article 47 of the measures it took some 13 years ago as part of the bailout. In fact, the claimant's own case is that CARICOM discussed this issue in 2012 and 2018. You will see this at paragraph 54 of the originating application and Annexure L to the originating application. And there was no suggestion that CARICOM ought to have been notified. So in our respectful submission, that submission is plainly wrong. We ask the court to note carefully how the claimants in their submissions are trying to reformulate their case. They're now saying that this case is really about the regulation or control of economic activity in the form of the provision of insurance services. You will see this at paragraph 4 and paragraph 24 of their submissions at pages 2202 and 2208. They also say it's about rules or policies which apply to the activity of providing insurance. You will see this at paragraph 8 at page 2203. But respectfully, the bailout does not fall within the definition of services in Article 36(4), which says that services means services provided against remuneration other than wages in any approved sector. The claimants have expressly pleaded that they do not base their claim on a proposition that the state supplied insurance services, as in fact it did not. You will see this at paragraph 41 of their reply at page 1618. But rather on the proposition, they say that the state intervened in or regulated the supply of insurance services in a discriminatory manner. We say that notwithstanding this impermissible attempt to reformulate their case after the close of pleadings, no one, and certainly none of your honors, reading the claimant's pleadings can conclude that the claimant's complaint has anything to do with the provision of insurance services as defined in Article 36(4) or the regulation or control of the provision of insurance services or rules or policies which apply to the activity of providing insurance. Because it is after the two local insurance companies, CLICO and BAT, failed, or to use the claimants at paragraph 29 of the originating application, collapsed into insolvency and were no longer able to provide insurance services, that the state of Trinidad and Tobago stepped in to provide relief to the policyholders. By that time, the companies were under the control of the central bank because they were licensed by the central bank to carry on insurance business in Trinidad and Tobago. The claimants accept that this too was the starting point for their complaints about BACO, and you will see this at paragraph 43 of the originating application, and paragraphs 29, 34, 49, 51, and 52 are clear that what CLF sought from the state and what the state provided was, to use their words, financial assistance or support, which the claimants contend ought to have been extended to BACO. So in our respectful submission, even on a prima facie basis, Articles 36, 37, and 38, which the claimants invoke, do not apply, and the claimants cannot now seek to dress up their case so as to seek to avoid the effect of Article 32 and 3. The claimants' related contentions in their submissions are simply not consistent with the claimants' own pleading and the undisputed fact that what the claimants are really challenging, and in other words, the target of the challenge, is, to use their words in the originating application, the decision of the government of Trinidad and Tobago to rescue certain of CLF's insurance and financial subsidiaries. In other words, the bailout, financial bailout, or the provision of relief by the state of Trinidad and Tobago, or as they call it, the BA Rescue Plan, which did not include the policyholders of the Bahamian company, BACO. As we pointed out in our reply submissions, which you will see at paragraph 13, taking the claimant's fields of activity, which is the expression they use at paragraph 8, page 2203, or areas of activity, which you will see at paragraphs 21 to 23 of the skeleton argument at page 2551 to 2552 argument, its logical conclusion, it would be out with Chapter 3 and therefore lawful for the state to use its financial resources to intervene in or rescue services in the sphere of policing, but it would be within the scope of Chapter 3 and therefore challengeable if the state were to engage in that very same activity of using its financial resources to intervene in or rescue insurance companies who are providing insurance services. Respectfully submit on a natural and ordinary meaning of Article 32, this is not the result which the contracting parties to the RTC intended when they included Article 32 and 33 in the treaty. And if the claimant's submissions were to be upheld, we say it would denude Article 32 of any practical effect and render it all but meaningless, which is in breach of the principle of effectiveness recognized by this court as a principle of CARICOM law in the SM Jalil case, which you will find at tab 7 of the claimant's bundle at page 2375. Respectfully, we submit this cannot be a result which any court will sanction, because upholding the claimant's contention not only runs contrary to the express language, ordinary and natural meaning of Article 32 and 33, but it will have the effect of undermining clarity and legal certainty within the community, principles which this court in cases such as Mary, SM Jalil, and Tomlinson has long recognized. To the extent that the claimants go to the other extreme and say that the defendant's interpretation of Article 30 will make much of Chapter 3 a dead letter, which you will see that submission at paragraph 24-2208, we say that this is no more than a floodgates argument which really holds no water. As is evident from this court's approach in Mary, wherever a member state invokes Article 30, the court will properly consider the facts of the case, including the nature of the relevant activities in question, and it will determine whether in the circumstances of that particular case, the activity challenged falls within or without the scope of the chapter. This is a role which we are confident this court will not shirk, particularly where the activities in question, as in this case, plainly fall within the express language of Articles 32 and 33. To the extent that the claimants in their submissions seek to rely on the distinction in the GATT regime between services and measures, and to draw support from the ECJ case law for the interpretation which they commend to this court, we ask the court to note that while those provisions have similar purpose to our Article 30, our treaty in Article 30 does not use that language of measures and services, and therefore they do not assist the court in the exercise which it must undertake. To borrow again from the dicta of the House of Lords in the Roma rights case, no matter how generous and purposive its approach to interpretation, the court's task remains one of interpreting the written text of the treaty, as it is this document which reflects the agreement of member states. The court has no competence to interpret and apply the provisions of other multilateral treaties, as this court has recognized in Mary and the 2022 Rockard distribution case, which you will find at tab 3 of the claimant's authorities. So in all the circumstances of this case, we respectfully conclude by inviting the court to answer the two preliminary issues in the following manner. One, assuming for the sake of argument, the truth of the matters pleaded by the claimants in the originating application, the actions of the state of Trinidad and Tobago alleged by the claimants fall outside the scope of Chapter 3 of the RTC because they fall within the meaning of Article 32 and Article 33. And secondly, this being the case, the court has no jurisdiction to adjudicate upon the alleged breaches of Chapter 3 raised by the claimants, and as such, only the other aspects of the claim founded on Article 184(1)J may proceed as the court may direct. Unless we can assist your honors further, those would be the defendant's respectful submissions.
Yeah, there's one issue I'd like to get your views on, and that is it conceivable that a state can engage in activities involving the exercise of governmental authority conducted neither on a commercial basis or in competition with one or more economic enterprises in a manner that flouts Article 7? And if the answer to that is yes, then are those activities still exempted from the provisions of Chapter 3?
A freestanding provision, because it is prefaced by the words within the scope of application of this treaty. So to determine whether there's a breach of Article 7, you must first, and assuming it arises under Chapter 3, you must first engage Article 30 and determine whether the activity in question is within or outside the scope of the chapter.
So as far as you're concerned, as long as you are within the exemption of Article 30, then Article 7 does not arise.
If we are dealing with a Chapter 3 challenge, yes, that is correct, because we only get to 7 in this case because of Article 30. Article 30 says, as we contend, these particular activities challenged do not fall within the scope of Chapter 3. And therefore, since Article 7 is premised with the words within the scope of application of this treaty, insofar as the claimants in this case seek to rely on discrimination on the grounds of nationality only, they must be able to pin their case on activities in Chapter 3 that are not excluded. In other words, activities which are on a commercial basis or in competition with enterprises.
I think I understand then, Mrs. Speaker, that you're saying that once, if we agree with you, then the claimant's claim under Article 7 also goes?
That is correct.
Thank you. One other issue that I looked at, Mrs. Speaker, Article 7 refers to discrimination on grounds of nationality only. But Article, is it 38 on the removal of restrictions on banking, insurance, and other financial services? That speaks only to discriminatory restrictions. So I take it that if we had come to this, you would have said to us that this use of the word discriminatory would be wider than Article 7?
Oh, yes, I couldn't but accept that it was wider because there is no delimitation as contained in Article 7. But of course, you only get to Article 38 if you pass the threshold door of Article 30.
Thank you.
Yes, does anyone else have any questions of Mrs. Peak? No? Okay. Thank you very much, Mrs. Peak.
Much obliged.
Mr. Davenport, are you ready to proceed?
I am, Your Honour, and I'm grateful for the opportunity. And like Ms. Peak, I will try and keep to the time period. I think we were given an hour each. I think Ms. Peak has a short right of reply. She's used up a bit of her time of that, but we'll adhere to the 1 hour rule, hopefully comfortably. As you know, these are the oral submissions. Can I just make it clear that this is an attempt at synthesis of the existing arguments? Those are very much leaning upon the written submissions. The fuller written submissions are the initial response to the defendant's submissions in support of his application. Then there is the short rejoinder clarifying 1 or 2 matters. And then the skeleton argument, from which you've only had from us, is something between a skeleton argument and a speaking note, I suppose, but is an attempt at a synthesis again and drawing all of the threads together. So we very much leave.
Sorry, through you, Mr. President, could I just inquire? On the issue of the short rejoinder,
yes,
that you just mentioned, I am not clear whether your application to the court has been considered. It may have been in my absence, but to the extent it has not been, would this be a good point at which it could be?
Yeah, if it's contested, I got the impression listening to the submissions of my learned friends that the matter is not really disputed. And of course, I'm very.
With respect, counsel, I don't think that's the point.
Well, I'm very happy to express it.
Well, if I could explain what my understanding of the point is that you had sought to produce materials in the form of a short rejoinder. And you had then indicated that you would have sought the permission of this court so to do. And I am just inquiring whether that process has run its course, that's all.
It doesn't appear to have run its course. I haven't received.
Well, and so sorry. So what I'm now asking is whether this is a good point at which we could take that point up.
It would seem to me to be the obvious point, Your Honour, to take it up. And my first point is it doesn't appear to have been contested, because at the end of the day, if it's not being contested, then it's not an issue that needs occupied time. If, on the other hand, it is contested and an application is resisted, then, of course, I'm happy to address it. I merely say that my learned friend has already made reference to paragraphs within my rejoinder and reference to authorities within my rejoinder, and that is only consistent with my learned friend not contesting the application.
Thank you. Well, for just proper housekeeping, may I say, President, I have no objection at all to the submission of the rejoinder, but just for proper housekeeping, perhaps a ruling on the point might be in order. Thank you, sir.
Yes, please proceed, Mr. Davenport. There's no objection to it. We are not a lay jury, and these are matters of law, so that please proceed.
I'm very grateful. So therefore, the written submissions are the core of our submissions to you, and I will try and expand upon the realities of some of the oral arguments, some of the mistakes that appear to be being made consistently by the government. Can I start off with an error? My only friend, I'm sure there were good reasons for it, but literally forgot to give you part of our case. Can I just remind that the third claim is to be found at paragraphs 13 to 15 inclusive of the originating application. So can I ask that to be taken into account? And while I'm on it, can I just deal briefly, I hope, with 2 points. One is there seems to be a floating allegation that the pleaded case has changed. We feel a bit bemused by that because we think that the same case has been consistently put forward, and in particular, it's not a strong start by my learned friend not to actually summarise our case correctly. It trifurcates, and it clearly falls within part 3 jurisdictionally of the treaty. I remind everybody that, of course, for the purposes of a preliminary issue, that the matters have to be assumed as correct as pleaded. The longer version of the particulars is to be found at paragraphs 35 to 54 of the originating application, and also paragraph 19 of the reply. And there's a lot of facts there, which I certainly won't go through. As to the trifurcation of the claims, the first of those claims is that the intervention was discriminatory on the ground of nationality, and that cross-border provisions of services under Article 36.4 and a measure taken by the member state to provide redress for consumers under Article 184.1J is triggered. And the allegation squarely is made that it fell within the scope of the treaty because it was discrimination in the field of cross-border provision of services. Secondly, the intervention amounted to a restriction on the provision of services for BA International, by which the allegation is made that the government actively took steps which damaged the interests of the BA International policyholders. And thirdly, and this was what was omitted, the government failed to remedy what was a discriminatory statute. And that failure to remove such restrictions contravened Articles 37 and 38, and also was a failure to take appropriate measures to promote the interests of consumers, contrary, as I said before, to Article 184.1J. And there are a number of factual steps which are prayed in aid, which make good the allegation, the allegations, plural, that I have just drawn your attention to. And whilst I'm going along, I may as well deal right at the outset with the very helpful intervention by Mr. Justice Anderson and also Mr. Justice Jamadar about why does the defendant's argument on Article 30 denude Chapter 3 of effect, and it being characterized as potentially simply a bailout, not a commercial activity, to which we can expand later. But rhetorically, may I pose this question: what does simply a bailout mean? I mean, we say that in this case, it amounted to an intervention in the insurance market. The government helped some participants and hindered others. All government rules and policies governing markets and all interventions in markets can have the effect of favouring some participants and hindering others. That is the scope of Chapter 3. to make sure that such interference does not impose restrictions on the four freedoms and does not discriminate. And in this respect, governments cannot just pick winners and losers, which is precisely what we respectfully submit the government did in this case. And emergency interventions are not to be treated any differently. Chapter 3 applies to such interventions and provides express exceptions, as we mentioned later on, Articles 43 and 47, where the rules of Chapter 3 lead to hardship. Even in such a state of exception, member states must not discriminate. So a government intervention does affect the private sector. The private sector is driven, drives rather, the nature of the CARICOM single market and economy. If it discriminates, it precisely its purpose, especially if it discriminates between foreign and home investors or service users or service providers and the sake. And so it's respectfully a red herring to say that they're not asking the court to give a full definition of Article 32. Their construction allows unrestricted intervention.
But Mr. Davenport, the premise of your claim is that your clients were service recipients.
Yes.
Complaining about the interference of their access to the services. Is that correct?
Yes.
Who is the service supplier? A collapsed company?
Yeah, British American.
And at the time of the activities that you complain about, the service supplier had collapsed, was insolvent. Is that correct?
Well, I'm hearing sotivology. Potentially, I mean, it was in the state of collapse.
Potentially, or it doesn't. The originating claim clearly indicate that the service supplier had become insolvent.
Yes, the service supplier had become insolvent. It's just a moving picture of various at various times of solvency, and we put it on the basis that there was declared insolvency, but that there were various stages while that insolvency or solvency was in the balance, I think is the better way of putting it.
You see, what I'm having difficulty with is understanding what provision of services was thwarted by the intervention of the state of Trinidad and Tobago?
Well, the correlative rights, amongst others, of the receipt of non-discriminatory insurance services. They were treated in a manner which was, and set out at some length, completely differently to the way that some other subsidiaries of the group had been treated. And in that sense, there was a completely different scheme of treatment for the for BA International and the policyholders of BA International in various different ways.
So the claim is really about alleged discriminatory treatment.
Correct.
Okay, proceed.
Thank you. Well, we are here, I remind myself, this is not the trial, this is the preliminary issues. You might recall that I had tried to submit that one should be very careful about preliminary issues, that it's very difficult to separate them from the factual matters which are going to be determined in the trial. And part of the strictures of dealing with preliminary issues is that one has to take the facts as they have been pleaded in the originating application. And so my learned friends' exhortations to cut through the Gordian knot and look at the realities of what the facts were, I'm afraid runs straight into that problem or that rule. I'm afraid you have to take the facts as we have pleaded them. And it's not at this time to divine some different set of facts other than that. But
no, sorry, counsel. I thought the other side had agreed for the purposes of these proceedings to accept the facts as you have presented them.
Correct.
Is that not satisfactory to you?
That is very satisfactory. What I'm saying is that the submissions appear to resile from that, I think, is all I'm trying to say to you.
Okay.
In any event, I'll proceed with my submissions. So we submit that the court should find that the actions of the defendant, which are the subject of the claim, fell within the scope of Chapter 3 and are subject to the scrutiny of this court. They do not fall within the exception described in Article 30, sub-Article 2. The claimant's position is therefore a correct reading of the ordinary meaning of the terms of Article 30, sub-Article 2 in their context and in the all-important light of the treaty's object and purpose. The defendant's position, we respectfully submit, is a somewhat isolated and cherry-picked, alternatively misconceived and literal reading of some part of the treaty, namely Article 32. A literal reading of a single article or part of an article is an incorrect approach. I refer you to the Trinidad cement case determined by this court, where references to the Vienna Convention were made to. And I note that my learned friend keeps saying that it's agreed as the approach to the treaty. That's, I think, because we have referred to broadly the same materials, or I think you might start with the materials that we have given you in our submissions because they're of wider cast. But they're not applying them in the same way or the appropriate way. So we very much differ on that. The number bit in Trinidad Cement was paragraph 11 of this court's ruling. And I just read it without you having to refer to it. In interpreting the RTC, the court does not intend to place undue reliance on a literal approach. Reliance on the text of a treaty to the detriment of its object and purpose is contrary to the rule expressed in Article 31 of the Vienna Convention and does not accord with the jurisprudence of the International Court of Justice. As Orst states, placing undue emphasis on the text without regard to what the parties intended or on what the parties are believed to have intended, regardless of the text, or on the perceived object and purpose in order to make the treaty more effective, irrespective of the intention of the parties, is unlikely to produce satisfactory results. The RTC establishes the Caribbean community, including the CARICOM single market and economy, and its preamble is an important part of its context for the purposes of interpretation. Through the preamble, one is made aware of the goals of the states parties and of statements of principle by which they propose to be guided. So the object and purpose of the RTC can be found in its full title, the Revised Treaty of Chaguaramas, establishing the Caribbean community, including the CARICOM single market and economy. It can also be viewed in the provisions of its preamble, including those referred to by the defendant actually in its own written submissions, which are referred to at paragraph 9. Put simply, the creation of a single market and economy would be impossible if member states, simply because they're acting in the exercise of governmental authority, were able to interfere in the exercise of the four freedoms in a manner contrary to their obligations under Chapter 3 of the treaty. To read Article 30, sub-Article 2 correctly, one has therefore to consider the meaning of all of its terms in the context of the rest of Article 30 and of Chapter 3 and the treaty as a whole. And one has to consider the object and purpose of the treaty. I refer to our submissions at paragraph 14 onwards within the primary submissions, and particularly looking and taking cognizance of paragraph 17 and 18 in our skeleton argument. I just refer to that. The overriding principle is that full effectiveness should be given to a person's rights under community law. That's the Jalil case reference. And 18, applying those principles, the claimant interprets Article 30, sub-Article 2 in the context of Article 30, sub-Article 1, Chapter 3, in a manner which gives effect to the rights granted and protected by Chapter 3. Now, if one takes that approach, which is full effect and by definition a narrow interpretation of any exceptions, one clearly sees that it is not enough to meet the exception in Article 30, sub-Article 2, merely to say that what the government did was done in the exercise of governmental authority. That's the defendant's argument.
See, one of the problems I'm having, counsel, and this permeates a lot of your submissions, is that you are treating what is stated in Article 30, paragraphs 2 and 3 as an exception. So could I ask you, what are those provisions an exception to?
Well, they are an exception to they're an exception to the general application of Article 30 and Chapter 3. I mean,
no, well, you see, that's the problem, because my reading of it is that we start with a delineation of the scope.
Well,
are then, if I may,
I can
of
hear
the
you.
scope, which is, yeah, I'm sorry about that. Of the scope, which is then described in the article, or in the chapter actually.
Well, I don't know.
But Article 7 also speaks of the scope of the matters to which it applies. So that I'm not sure of the sort of general right that you're speaking about, because both seem to delimit the area of their application, if you will.
Well, where we end up is to submit that the right of establishment, the right to provide services, and the right to move capital apply to all areas of activity except for governmental activities or functions. And that means that when a government makes rules governing or policies affecting an economic activity, the government's actions are subject to the scrutiny of Chapter 3 unless the underlying activity itself has a governmental character.
Yeah, well, that really takes a lot of liberty with the wording of the provision, I have to say.
Well, I, with the greatest respect, disagree. I say that's really driven to be the only natural reading. And if you look at the submissions that we make in respect of the rather ambitious and bold submissions made by my learned friends, wrongly relying in support of EU decisions and parts of the GATT treaty, you can see that where this is being deliberated upon, that's the answer that you end up with. You have to look
before we get, I'm sorry to interrupt, Council Casey, but before we get there, you see, I'm just trying to follow you, because you see, there is a distinction between a situation where, okay, there's an echo. Yes, well, there is an underlying right, and then there is an exception to that right. I accept that. And that was illustrated very well, I thought, in the bananas case in the WTO jurisprudence. That is to be distinguished from a different situation where there is no continuous underlying right, but where there are separate fields of activity or separate fields of application of rules of law. And if Article 7 is saying to you that this is one area where it applies, and Article 30 is saying it's another area where it does not apply, then I don't see the underlying rule to which Article 30 is the exception. Sorry, am I being clear?
I think you're being clear, but unfortunately we might be, I don't want to be obtuse, and I don't want to be like ships that pass in the night, not addressing your concern, because it's our firm submission that you've got to read Article 32 in a series of contexts. You've got to read it in context with 31, you've got to read it in context with Chapter 3, you've got to read it in context with the entirety of the treaty, including the preambles and the objects and intent, the goals, as it were, that are being achieved. And we're saying that Article 30 is not saying that it doesn't apply. So we end up, I'm afraid, with a natural interpretation, which I think we set out at some length, is that if you look at those contextual provisions, that you end up with a series of rights which apply except for governmental activities, and that's natural because there will be some things which is right that are excluded from very important and fundamental rights, the 4 rights within Chapter 3. Those are always going to interact with government's decision making, and government decision making and rules, regulations, and any other exercise of governmental or authority is going to be acceptable on the basis that it is dealing with underlying governmental activities. And
is that not protected, Council, by the fact that the governmental activity is defined in a way to exclude commercial activity on the part of the government?
I'm sorry, do you mind if you repeated that? You were breaking up a bit during that.
Yes, no, your point. Is that not taken care of by the fact that the definition of governmental activity is such that it does not include commercial activity by the government or activities in competition with economic enterprises?
No, I mean, our submissions are that's actually not relevant for the purposes of this interpretation. You don't. It's again a red herring. That's not necessary. I mean, the logic of the defendant's argument, if you look at where the parties end up, is that any act done really in the exercise of governmental authority is exempt from the strictures. That's the obligations of Chapter 3. And of course, the president asked a question of my learned friend saying, well, are you saying that therefore they can act with impunity? I'm not quite sure what the answer really amounted to. It amounted to an attempt, I think, to say, well, each case turns on its own facts. I don't like the word impunity, and in these circumstances, it would be an appropriate application of her interpretation. But we're talking about interpretations of a wider application than just this particular case. And what is being submitted surely must be that any act done in the exercise of governmental authority is exempt from the strictures of Chapter 3. Any act within this collective activity. Can't hear you, I'm afraid.
Possible. I'm hearing you perfectly well, but
I'm not alone in the room.
I'm sorry.
We can't hear you.
Justice Anderson, you just broke up a little on my side as well. Yes, thank you.
Yes, I could try my headpiece. Sorry, is this any better?
So far, very much.
Can you hear me
clearly?
Okay, wonderful. Wonderful. Yeah. Okay, please continue, Councillor. I didn't want to.
Yeah, I mean, I think.
Mr. Davenport, before you continue, I know that several people listening to a speaker may get different impressions, but I certainly did not get the impression that Mrs. Peake was saying this applies carte blanche to every situation. I thought she was very careful from the start to say the facts of this case are such that this is how you should interpret Article 30. That certainly was my impression.
Well, I respectfully fully agree with you. I'm sorry if I gave the opposite interpretation. What I think I was really saying was, while she tried to do that, it's not possible to do that. It's not permissible to simply say that each case turns upon its facts, because the position that they are choosing in this case to take this interpretation must lead to a much wider application of her interpretation of Article 30, sub-Article 2. And that's not going to be capable of being read down as just the facts of this case. That must therefore lead to a much wider interpretation. And anyway, it's wrong for a large number of reasons that we have set out, and which I'm hoping to develop. But I'm very happy to accept that my learned friend wanted to say that it only relates to the facts of that particular case. Obviously,
so just a minute. So do you agree that a court in determining whether the exemption is can be had would have to look at the particular factual matrix in which that exemption is being claimed? Do you agree with that view?
Effectively, yes. That's why I tried to resist a preliminary issue happening in the very first place, praying in aid that many appeal courts and
No. Well, they are content,
yeah.
And that is the premise on which the preliminary issue was formulated.
Yes.
They are content to accept all
fact.
of the facts which have been placed, which have been placed in the claim.
Yes. So I agree. I mean, we're not disagreeing about anything, and in those circumstances, whilst I think generally speaking, it would be safer to make these sorts of interpretations on the back of facts if it is being asserted that it's cases of whichever case per fact. I mean, my learned friend's primary position, and I addressed this to Madam Justice Rajnath Lee, is that, well, you've got to look at the factual allegations. To take Mr. Justice Anderson's point is, well, she's allowing you your own interpretation of the facts, fair enough. But nonetheless, my learned friend's position is it's a factual-driven interpretational context. What I'm more interested in is the fact that I doubt that, but if it was the case, then what are we doing here at a preliminary issue? If it was the case that it was going to be interpreted as just pure law, then I'm suggesting that I'm afraid it has to be driven into a conclusion of what the state of the law is on much wider application. And I think that's where actually the position of this interpretation really does rest. So,
Mr. King's Counsel, we do have your written submissions, and I find it very fascinating to interact with you in this way because the written submissions can be read at leisure. I wanted to invite your attention to a more philosophical discussion of the issue. And that is whether, in your view, the framers of the Revised Treaty of Chaguaramas had it within their power to reserve certain areas for the exercise of their sovereignty and to allow other areas to be pooled sovereignty. In other words, based on what you're saying about continuing rights, it's almost as if you're saying the framers could not have intended for the definition of governmental activities to be the way that your operative counsel is suggesting. And I'm asking, from a philosophical point of view, why not? Why is it that they could not retain to themselves that area of their in the Revised Treaty?
Well, I think what I'm saying is that they could have, although it would have been very odd to end up with a treaty whereby such a limited amount of sovereignty was bargained away for the purposes of achieving the joint bargain, which is the CARICOM treaty. So you wouldn't have ended up with much, and it wouldn't have protected the citizen state much.
No, but King's Counsel, how does that affect the private sector driven nature of the CSME? Because we have established before that continues unabated. And if the government was to attempt to intervene by providing commercial services or assistance to economic enterprises, it would come under the discipline of the Revised Treaty. So I'm not sure why you say what you say, that that would mean that only a very small area of sovereignty would have been surrendered.
Well, when I make those comments about sovereignty, which was a preamble comment, I'm making specific reference to how it's put in the rejoinder that's now admitted, which is age-old sort of philosophy, really, of what lies behind such treating with sovereignty, which is that there are as it were, chosen dilutions of sovereignty for the purposes of the significant benefit of what is in a treaty such as the Revised Treaty of Chaguaramas. What I was going on to say was that regardless of all that, that isn't where the analysis of the interpretation of this treaty should lead you, because of what is inside and what is outside of this treaty. And you've got a number of examples before you, since we're talking about the overview question that you ask. There are, for example, these other articles, 43, 47, and 48, being a part of them. Article 225 and 226 in Chapter 10 being other articles, which provide for precisely the visceral reasoning for or relied upon for why the interpretation is as my learned friends say it is. There clearly would have been other ways of being able to get community-wide support by the organs of the state, having a report to them of the intention of an abrogation from those rights. And that hasn't happened. It hasn't been triggered. There hasn't been any notice period. What has happened is there's been unilateral activity by Trinidad and Tobago. And in that case, there hasn't been any consideration. There appears to be in the materials no consideration whether or not those other articles should even be looked at or engaged. And so that's one aspect of the article and the answer. The other answer is, for example, where we have conjoined on the GATS treaty interpretation, is that there very clearly has been a decision what to include and what not to include in the treaty, which has been selected from other helpful treaties around the world. So you really are. I agree, it's very relevant to look at that, but you have to look at that in realizing what you do have to interpret, and what you do have to interpret it is, as we attempt to say, a Chapter 3, which is a basket of rights. It is the preamble to which is Article 30, the carve-out to which is within Article 32, and for all the material that you've seen already in writing, all of these roads lead to an interpretation that you have to put Article 30 together, all of it, 31 and 32. 32 deals with 31 and is a relaxation of 30 within Chapter 3, within the treaty. That being the case, that is really a reading together of those, and I respectfully repeat what its natural and indeed its ordinary meaning would be in those circumstances is that those rights apply to areas of activity apart from governmental activities where the underlying activity is of a governmental nature. And that makes sense, because otherwise you don't have any rights which are going to greatly affect the private sector and the citizens of these member states of this of member states in circumstances like this. And therefore it's really got to be read in the way that we submit.
And the example you gave is that of the police service, was it?
We give a couple of examples. We think the Myrie case is itself a good example.
But if we said for a moment with the provision of police services,
yeah,
how does that square with the notion of activity not being provided on a commercial or in competition with other enterprises?
I don't know if it has to be squaring with it. I don't really understand. Sorry, the question. Do you mind putting it to me again?
Yeah, no, I was just, in other words, if you were to look at the definition of governmental activities in the way that senior counsel on the other side was suggesting, then it does make sense, because it then says, well, look, if the government is going to intervene in the CSME on a commercial basis, then it comes under the discipline of the RTC. Now, the way you are reading it poses a problem for me to understand, because if you're talking about the provision of state services in the form of the police, you would not necessarily be talking about the provision of commercial services or services in competition with other economic agents. I don't know that the state normally has to face competition with other economic agencies in the performance of police functions, do they?
Sorry, I'm just taking a note. Thank you. One of my juniors wants me to read this. Yes, well, I agree with this. It's not a question of government intervening on a commercial basis. It's a question of intervening on commercial activities. I mean, this is what I've said already, which is that it's not you can't sort out the wheat from the chaff of what has an impact upon commercial activities in the private sector. And even in the interfacing between the government and the private sector. So that's why we say repeatedly that it's beside the point. This distinction, we didn't make a fight, and it's clear that that wrong-sided the government of commercial activities. And that's what they say was a large concession. And that's what we've corrected as not being a concession that's relevant in our rejoinder. So in those circumstances, we're just talking about a different route to interpretation, and we haven't made a concession that matters. I'm afraid to say that's where we're at, and you have to determine the positions between the parties.
Mr. Davenport, I know you've been interrupted a lot, but you said that the rights apply to activities where the underlying activities are of a governmental nature, and I think that is at the heart of your submission, so that the test to be applied here is not to focus, from your point of view, is not to focus entirely on whether or not this was a bailout, but to look and see what was the nature of the intervention in fact. And because the underlying activity, that is to say, the provision of insurance services, for the purposes of the CSME, is not of a governmental nature, it doesn't fall within the exclusion. Am I correct that that is what your submission is?
That is correct, yes.
And therefore, the analogy, whether in Myri or of police services, follows because the underlying activities are of a governmental nature, i.e. police services, etc. Do I understand that correctly?
Correct, completely correct.
Yeah, okay, thank you.
Right, that's very helpful, thank you. And thank you, that's as it were, saved a lot of our submissions anyway. So if I can just sort of reset, so we do say the answer is activities in a member state means the underlying activity, which is the field of activity, which may or may not be subject to the member state's interference, and not the activity of interference by the member state. 30.1 applies to activities to which those very rights attach, except where such activities are governmental activities. And I've said this already, but Article 31 defines the scope of Chapter 3. The rights mentioned, various rights, don't exist in the abstract. If so, they would be meaningless. The rights allowing persons to engage in particular forms of activity, and Article 30 sub Article 2 simply provides an exception to this, so that activities in the exercise of government authority are exempt from the application of these rights. And that's the practical examples that you've seen in the EU cases, in the ECJ cases. There is very much a different treatment for certain type of governmental activity. It doesn't give a license to member states otherwise to interfere in the other's exercise of those rights. So, I mean, this court will recall that most of the provisions in Chapter 3 are concerned with restraining governments from interfering in fields of economic activity or with directing them to remove obstacles. And this is where the states are acting as sovereigns. In other words, Chapter 3 is all about restraining the exercise of governmental authority when that authority might be used to interfere in the right of establishment or the right to provide services in all fields of economic activity. And when we say interfere, we mean, for example, the variety of expressions of exercising of public powers, legislation, regulation, or otherwise, governing economic activity or by applying policies which affect economic actors. So what Article 32 is not directed to considering is whether the rulemaking interference by the government itself involves an exercise of governmental authority, but rather whether the underlying activity involves the exercise of governmental authority. And the question that you therefore have to answer is that activity sufficiently governmental to be exempt from the four freedoms? I mean, another way of putting this is, do the rights in Article 30 apply to this area of activity? i.e., for example, setting up business, for example, the insurance provisions, or do they not? Are they more concerned with setting interest rates or national security or policing, for example? And that leads us to our conclusion, which I've now said twice to Mr. Justice Anderson and the rest of your honours, which is that surely, therefore, the only natural reading to this, before it is sense checked, and of course our submissions trifurcate. It looks at the, normal interpretational principles, which I've tried to outline. Secondly, looks at how this court dealt with in the Myrie case, and although perhaps we don't need to go to it now, I do ask you to look closely at particularly paragraph 57 of that. And thirdly, how dealing with matters that Maloney Friends have introduced, they weren't introduced by us, but since they were introduced by Maloney Friends, how that has those provisions, where they are the same, because they're not in GATS, but where they are the same, have been answered by courts looking at those different treaties. So addressing points made by the defendant, I mean, the defendant's chief point is really that its actions were taken in the exercise of governmental authority and are exempt from Chapter 3. And I tried to show that that's wrong because it fails to consider what kinds of activity 30 sub-article sub 32 refers to. The defendant's argument at the end of the day boils down, we respectfully submit, to the proposition that anything a government does in the exercise of governmental authority is immune from scrutiny under Chapter 3. And that's
no. With respect, I don't think that they're quite saying that. At one time, I thought that too. Right. But I thought that Mrs. Peake placed this in the context of, and she said so, the specific activity and the purpose for which that activity was undertaken and the context in which it was undertaken, so that it would contradict Myrie to take the view that any and all governmental activity that is neither commercial nor in competition with the private sector is absolved from scrutiny against the exercise of Chapter 3, the rights indicated in Chapter 3, because that was specifically the case that was said in Myrie. The state of Barbados put up that defense, and the court did not agree with it.
No. Well, I have to say, we've been accused of shifting sands, which I think is a little unfair, but I did read all of the documents put forward by the government as still trying to maintain that. And I think you too must have thought that, Your Honour, because having read all the material, you felt the need to ask the question. If it is that it's been climbed down from, that is a change of position. But although that's said today, it's hard to get away from the feeling that that's really what the government were trying to argue. And I don't think it's a natural argument for them to limit it in the way that they have. We've tried already to answer that, so I shan't repeat it. There are other points, of course. That was the central point. One of the points is that the claimant's approach would prevent member states from taking prudential action in the public interest. And that was the main submission at, I think, paragraph 26 of their submissions, to which we, paragraph 26 was their submission. We replied, I think, at paragraph 20 onwards. In the skeleton argument at paragraphs 26 and 27, we have addressed that by showing you articles 47 and as well articles 43 and 48 and articles 225 and 226 in chapter 10. It's interesting just to remind ourselves of how those would have worked. Had Article 47 been engaged, and that was obviously the article to engage, that specifically would have ushered in a prudential macroeconomic and political solution that is specific reference to one part of GATS Annex 1 that was deliberately incorporated, the rest deliberately not incorporated. And it required three things. It required, first of all, notification of the measures to the competent community organ, which would have been, I think, COFAP or COTED, and giving that organ the power to determine whether such measures may be continued in that way. But at the same time, there was no permission to discriminate in applying those measures. But as it happens, of course, no attempt to engage with Article 7 was made. And the context, why it's relevant in a wider consideration, is there's no attempt by the treaty draftsman and the member states' intentions to permit an unconstrained discretion, which is our concern, because the implication of the defendant's arguments as to the interpretation of Article 30, sub-Article 2, is that it would have an unconstrained discretion to regulate activities otherwise covered by the right of establishment, the right to provide services and the right to move capital, because state regulation is by definition an exercise of governmental authority. Chapter 3 and Chapter 10 of the treaty protect member states' national interests and permit them to respond to crises. There is no need for such a discretion, and that is dangerous territory. In addition, they require community supervisions and they have to prevent discrimination, neither of which restraints would have been preserved by the defendant's current interpretation of Article 32. Article 225 deals with essential security interests. Article 226 allows various exceptions, but as long as they're not discriminatory and are subject to community supervision. Paragraph 2, the next argument, which I'd like to just deal with, of the GATS Annex on financial services, allows member states to take measures for prudential reasons. And this is tenaciously held onto by my learned friends. This argument really goes nowhere because there is, and you really have to conclude quite deliberately, clearly, no provision in the treaty which is equivalent to paragraph 2 of the annex to the GATS taking measures for prudential reasons. That's because it's adequately provided for in what I've just told you about, including Article 47. The other, sorry, there's no coffee going. The other points that I draw your attention to it is that deliberately parts of paragraph 1 of the annex was included. And in our skeleton argument, at paragraph 37 onwards, which you can read in due course, we make the point at paragraphs, the end of paragraph 37 and paragraph 39, that both Article 1.1 of GATT and paragraph 1A of the annex therefore distinguish between measures taken by a member affecting the supply of services and those services themselves. Therefore, when defining services supplied in the exercise of governmental authority, Article 1B of the annex is not referring to the state conduct regulating such activities, but to the activities themselves. So that's a further tool in aid of the primary interpretation that we have addressed you on. And 32 should be interpreted to allow member states freedom of action in matters properly left to the democratic government of sovereign country, is another argument that they maintain. That's not really a new argument. It's another expression of the point that the defendant took policy decisions for prudential reasons and should be allowed to do so without observing the rules of Chapter 3. And that's frankly a bad point, because Chapter 3 provides for exceptions to allow for the exercise of macroeconomic policy decisions in a member state's public interest, as I've just referred to, and the defendant didn't seek to resort to them. The last argument really is the claimant's argument leads to an absurd result that a state may use its financial resources to rescue, they say, the police service, but not an insurance company. And we say that that mischaracterizes the effect of the claimant's arguments. The claimants are not contending that Chapter 3 or the treaty forbid a state from using its resources in the public interest to rescue an insurance company from collapse. Their argument, or our argument, is simply that Chapter 3 requires that if the state is to do that, it must do it in a non-discriminatory manner and in such a way as to avoid imposing restrictions on the right to provide services and cross-border services in particular. That's not an onerous burden, and we submit is not an absurd result. And really, those are the principal submissions that I wanted to give to you, apart from to obviously refer to our skeleton arguments, to the authorities that have been referred to in that, particularly at paragraph 34 and 36 of our skeleton argument, where in paragraph 34 we make a reference to the interesting case, the Servizi Ausiliari case. I've said at paragraph 44, in fact, can I tell you it's better to read 44 into 46, which is right on point. And we've quoted from 44, the freedom of establishment and the freedom to provide services do not apply to activities connected with the exercise of official authority. In other words, just as the claimants have submitted in relation to the RTC, the freedoms and the exceptions to them apply to the underlying activity. And as it were, as a corollary of that, the reference in paragraph 62 to the Reyners and the Thyssen cases are really supporting the claimant's argument. The first of those cases, the Reyners case, related to access to the Belgian legal profession, and the second was access to employment in the Belgian Insurance Inspectorate. In both cases, the court's decision was based on whether the particular activity, not its regulation, was connected with the exercise of official authority. And it appears that there's never been a decision that has gone the other way, and that it's only ever been interpreted as the underlying activity for the purposes of European decisions. So those, I believe, I'll just look to my left, are the primary submissions. Unless there are any further questions that you would like to ask me, I'll try my best to answer them.
Yes.
I think you're muted.
Yeah.
Mr. Justice was muted. I'm afraid you're still muted, I'm afraid.
Oh, okay, I'm sorry.
Yeah.
Yes, you said repeatedly that The government could do what it did, but it mustn't do so in a manner that discriminates, and it mustn't do so in a manner that interferes with the receipt of services or cross-border services. This may take you a little while to do, and maybe one of your colleagues could do it in the meantime while you respond to other questions, but I would be interested to know what paragraphs of the statement of claim, of the originating claim, demonstrate respects in which there was an interference with the receipt of services or with the with cross-border services being undertaken. Because the other side's position is that the activities undertaken by Trinidad and Tobago were undertaken after the service supplier had collapsed and had become insolvent. And so I am unclear as to what was the interference if the service supplier had already collapsed and had already become insolvent. In what respects can it be said that there was some interference?
Well, yeah. I think I can give you a good answer to that in a quick way. I think if you look at paragraph 11 of the originating application, you will see that that is to the point, which is the taking of steps that damage their interests. And that is before there was a declaration of insolvency. That's what I was trying to give you as the answer earlier, which was that the facts basically overlap pre-insolvency and during insolvency and post-insolvency. And what is being said is that the combined effect of a number of facts and acts led to a highly artificial situation in which an insolvency was created. And that you've really got to look at the way that it's put, which is, as I said, the particulars really run from paragraphs 34 through to paragraph, I think, 54 from recollection. That is a time span which is well prior to anybody's insolvency. And there was segregation in a very unnatural manner, and against the establishment of the of BA International as being effectively one limb of the same body of the corpus of British BA Trinidad. We set out factually at length why that was the case, and it's a prima facie very strong factual case. And then what is set out is that thereafter highly unnatural acts were taken, completely inconsistent with the history of the companies from at least 1997, being managed in a way which was the same. So it was effectively all a Trinidad and Tobago administration, Home Office, and venture. And that it was highly both irregular and artificial and uncommercial to treat them as distinct. But that was a deliberate act by the government who deliberately set out to do that. So they turned back time, artificially treated in a completely different way BA International, and then segregated them, and in a number of ways caused a considerable amount of financial harm to befall BA International and the policyholders behind it. And so they were treated in a completely different way. And it's impossible to sift out at this point anyway, any other, well, may I just cut to the chase? If Mr. Justin Anderson, as he quite rightly reminded me, if they have to accept our facts as the case, the total answer is that the acts of discrimination happened before insolvency, during any consideration of insolvency, and afterwards, so that the distributions are completely different. And as a freestanding point, the bottom line is that there was a completely different approach to the assets that were allowed to be used for the purposes of distributions to be made. So they interfered in the post-insolvency process. So if the question actually is rather as a matter of law, the criminal issue, that as a matter of causation, then they have a real problem, because there are a lot of facts to suggest that they artificially adjusted the position so that any post-insolvency payout were radically different to those of any other subsidiary within the group.
I have, if I may, 3 questions. I hope these are very short questions. I suspect they are.
I hope this.
We are here really because of Article 30, paragraph 2 particularly, and paragraph 3 as well. So if we could just return to that for a minute. I don't know if you have it in front of you, King's Counsel.
Yeah, I do on my screen. Thank you.
Yeah, I was hoping I had it in front of me, but I seem not to have it at the moment.
Okay.
But essentially, from memory,
shall I read it out?
Yes, you may. It's just paragraph 2 for the moment, please.
Yeah, it says, it's a single sentence. It says, activities in a member state involving the exercise of governmental authority shall, insofar as that member state is concerned, be excluded from the operation of this chapter.
Okay, so what I'm asking you then is, would you agree that the interpretation to which you urge us would require, for clarity, the insertion of some words? So, for example, if we said activities in a member state other than Chapter 3 rights, or activities in a member state other than the right to establishment, services, capital, movement of community nationals, etc., would you not agree that the insertion of those words would clarify the meaning to which you urge us?
Well, I'm afraid to say the answer, I'm sorry to disappoint you, but the answer I think is no to that. We say, for the reasons that we set out, that it's clear enough. If you allow me just to say as a sidebar, Mrs. Peake's argument does not consider to what activities in a member state even refers, whereas ours does. Okay.
For myself, I disagree preliminarily with you. I think that if the framers had said quite clearly that the activities do not include Chapter 3 rights, then I think your argument would be on very, very sound footing.
Well, could I attempt to be diplomatic and say that lots of barristers and judges find themselves in positions whereby at moments like this, they say that things could be clearer one way or the other if the wording was different. But what we are saying is that against the community of these sorts of treaties, that there are clear, these words are clearly understandable. Really, that's what I'm saying, is that they're clear enough.
Yes, no, I understand what you say. No difficulty with that. For my part, I would have thought it would have been clearer. But of course, to include those words would be to, in a sense, rewrite the treaty, to introduce materials into paragraph 2, which were never there in the first place. But you say that it's clear enough, and therefore you're not going in that direction. I understand you. Second question is, your clients would have received some compensation from their own governments or within their own jurisdiction?
They received some compensation from the judicial managers, and those are the sort of limited assets I was referring to. And there's something like 14%, as against 85% that their equivalents had, who are of Trinidadian and Tobagonian.
Right, but what I'm trying to get at, I'm sorry to interrupt, but just to make the point, what I'm trying to get at is that they received those benefits, the compensation, on the basis of the territorial connection they had with the relevant judicial managers, did they not?
Yeah. Yeah, I think it was not anything to do with territoriality or any territorial link. I think it was merely a payment out from BICO rather than, as it were, if you're in St. Lucia, you got St. Lucian assets distributed to you.
Right. But those kinds of benefits were not available to the policyholders in Trinidad, were they?
Well, I think I don't want to be sort of giving you wrong answers because of the heat of battle, as it were. But I don't know what the position is precisely. I'm just taking some instructions, but I've got a feeling that there were, as it were, there were available pools of assets, but there was effectively interventions in the way that we set out. Do have a look again at the originating application because it's all set out there. In fact, various different redistributions, enforcements of reassignment of assets. So therefore, different pools of assets are made available plus top-ups from the government. So there was all sorts of different pods, as it were, of value that came in, which was not the case with BA International. Not only were they not with, as it were, the same hand of cards, but they had some of the cards taken out of their hand, I think is the way that we put it. And I think that's the way that the facts are clearly pleaded.
So what I'm getting at then is that if you were to succeed both here and at the main trial,
yeah,
then the compensation which your clients have received would have to be taken into account.
Absolutely.
They're brought into hodgepodge, I think the Dutch say.
Yeah, that's right. Yeah, there would be full credit that would have to be given. I mean, I think that the way it's being put is that there was a 85% as the government's better deal led to 85% being offered to the Trinidad policyholders, and the Trinidad policyholders, by and large, with some exceptions, took it. And the payment out to the non-Trinidadians is 14%. So the natural claim value is effectively 71% of their policy, because they couldn't have got to 100%, they could have got to 85%. So they would only be able to claim for the top up, not, as it were, double sort of jeopardy.
Okay, great, I understand. And the third and final question is, on the other side, if you were to lose this preliminary point, I'm not sure you answered the question as to where we go from here. What would be the consequences for these proceedings if you did?
We set that out in our skeleton argument, and it's right at the end of our skeleton argument, and there's a variety of different conclusions. And if you have in mind paragraph 42 of the skeleton argument, what we say is that because there are three claims. The first claim has two limbs to it. One is the Article 36 limb that would be affected. So the Article 30 would be a roadblock to it. But the Article 181 limb, I think that must be 184. It's a
184.1J, right?
Thank you very much. Yeah, 184.1J. That would not be affected, and I think that's accepted by the government. So as it were, the main claim isn't affected. As to the second claim, that would be affected because it's Article 36, and that's in Chapter 3. Whereas the third claim, which you didn't learn about until I spoke to you, is in relation to Article 37 or 38. And whilst that is in Chapter 3, that limb would not be affected by the defendant's argument on Article 30, because there is no act of the defendant that is complained of. The complaint is of the defendant's failure to act as we say Articles 37 and 38 require. But in any event, there is an Article 184 claim, and that would not be affected. So I think the short answer is only the second claim would be affected and be prevented by the government's interpretation on Article 30. Otherwise, the claims proceed. I hope that's an answer.
Sorry, could you go over that again for my benefit? What articles would still be in play if you did not succeed today?
Article 37, 38, and 184.
37.
And Article 7, of course, I'm reminded.
But
Articles 37 and 38 would still be in play?
Yeah, we say they would be in play.
Could you help me understand how?
Yeah, because it was a failure to amend a statutory provision that was discriminatory, and it therefore was, although engaging with Article 37 and 38, nonetheless, it is not pointing directly to Article 37 and 38 and relying upon a direct infringement of Article 37 and 38. Yeah, and it's not about the underlying activity of the bailout. It's about the failure to have the right statutory provisions that would apply to the factual circumstances. Thank you.
Thank you.
So, unless those are any other questions, Your Honours, those are our respectful submissions.
yes, thank you, Mr. Davenport. Mrs. Peake, how long are you likely to be in your reply?
Not very long, Your Honor, certainly less than the 15 minutes that was allotted to me.
Yes, go ahead.
Much obliged. So can I take first, my learned friend's starting point that we ignored what he calls the third part of the claim, which he has described in his submissions as a failure to remedy a discriminatory statute, or as they put it in their submissions, a failure to amend. But of course, we don't accept that that is really the challenge, because when you look at paragraphs 13 to 15 that my learned friend referred to, you will see that it is all about, and they accept that this is so. BACO was never registered as an insurance company under the Insurance Act in Trinidad and Tobago. It was registered for the purposes of this claim in Antigua and Barbuda and in Grenada. And that is why they received the benefit of the judicial manager's distributions in those jurisdictions. So there's nothing inherently discriminatory about a statute which says that you have to be registered as an insurance company in Trinidad and Tobago. You could be a foreign company, but you can't carry on insurance business in Trinidad and Tobago unless you're registered with all of the relevant statutory fund requirements and so on. But really and truly, what we say is that this complaint is no more than a segue into their complaint about the bailout, because they're saying if we had been included in the regulatory regime, just like BAT was, then we would have received the benefit of the bailout. So it is not a freestanding complaint. And that is made clear when you look at the reliefs which are sought. You will see that they haven't sought to challenge or have the court strike down any provision of this Insurance Act or any statutory provision or say that it's in breach of the treaty. What they have sought to do is to say that, look, because we were not included in that regulatory regime, then we did not benefit, and therefore it fortifies their case on discrimination. So we do not accept that we have misinterpreted or misrepresented the nature of the challenge, which at its heart remains an attack on the bailout of BAT and the bailout of CLICO to the exclusion of BACO. And that is what their case is all about. We say as well, when you look at, my learned friend made some suggestion that somehow I might have interpreted him wrongly, but you know, BACO was not an insolvent company.
Mrs. Peake, I know you have limited time. So just your response therefore is all of those claims, if we agree with you on this, all of those claims go, and you've already told us, as does the Article 7 claim.
Correct. Yeah, so there is no, as my learned friend suggested, well, that particular aspect of the claim, what he calls the third part of the claim or the third claim will stand because it alleges a breach of Articles 37 and 38. We say no, properly construed. If you look at the pleading, it is not a separate complaint in itself. It is a pathway or route to the complaint of discrimination so far as the bailout is concerned. And therefore, once the court agrees with our construction of Article 30, then that goes as well. Insofar as my learned friend suggested, well, you know, there was no insolvency of BACO. In fact, that is not their pleaded case. If you look at the originating application at paragraph 43, You will see that that is accepted. And again, at paragraphs 32 and 33, 32 is a reference to the Coleman Commission of Inquiry that took place in Trinidad, which found that the underlying cause of the collapse of the companies in the CLF group was the defective business model. And you will see at paragraph 33, they say they avert that his conclusions apply equally to BA International, which is BACO. So that when my learned friend said, well, their complaint is even pre-insolvency and so on, no. Properly construed, if you look at the pleading, the case is about all of the companies, whether Clico Bat or BACO, were insolvent or certainly in the zone of insolvency by the time that the government intervened and decided to institute the bailout provisions. So we say that my learned friend is quite wrong in suggesting otherwise. And my learned friend makes the remarkable submission that, you know, there would be no challenge to the government having this bailout under Article 30. In other words, he would accept that it would fall out with Chapter 3, but he's saying provided that it was extended to everyone else. And he says that's not an onerous burden. Well, I mean, I don't know on what basis my learned friend can say that. The court doesn't even have an idea of what is the quantum of the claim that the claimants in this case make. But we know that it's 538 claimants who are asking to be made whole. And to suggest that that is not an onerous burden to put on a state which has decided which of the institutions at the request of CLF, even on their own pleading, because they put the MOU into evidence. CLF is the holding company which decided these are the companies that should be the subject of the bailout. And in exchange for that, these are the assets which the government can use to repay itself. So we respectfully suggest that that contention of my learned friend as to how Article 30 and Chapter 3 should be construed really misses the point completely.
Interrupt my learned friend, but these are disputed facts that my learned friend is now referring to, since we're on a template of only facts that we have asserted. I'd just like to be able to deal with that before her submissions are over.
There's nothing disputed about that, Mr. Davenport. It's in the MOU, which is annexed to the originating application. And that makes clear what was the bargain struck between CLF and the government of Trinidad and Tobago in exchange for the financial assistance. And we have not denied the MOU or any provisions of it, nor can we deny it. In relation to the question that the learned president posed to my learned friend, which is, you know, can you demonstrate where in the originating application there is any reference to the state interfering with the receipt of services or cross-border services? My learned friend tried to refer to a paragraph in the originating application. I believe it was paragraph 11, which talked about the lack of segregation of services. But with respect, that is no answer. In fact, there is no evidence of any interference by BACO or any of the policyholders of BACO who are the claimants in this case. There's nothing that government did that interfered with the receipt of those services, because at the time of the government intervention on the claimant's own pleading, BACO was insolvent and not able to satisfy its policyholders. So we say in respect of that, you know, my learned friend really has no answer to the question. Oh yes, and just as my learned friend was making his submissions and we were focusing on Article 30 as of course the court must, we wanted to draw to the attention of the court something that was not emphasized by any of the parties. And if we look at paragraph 1 of Article 30, you know, because we talk about exception and exemption and so on. Article 31 tells us frontally, save as otherwise provided in this article and Article 31, the provisions of this chapter shall apply, etc., etc. So even before you get to 2 and 3, the framers of the treaty are making it clear that it is what follows in relation to what is contained in Chapter 3 really is otherwise, what is otherwise provided in this article. In other words, it's saying from the very beginning, from the very inception of sub-article 1, that when you look at the breadth or the purview or the ambit of what is in Chapter 3. It is otherwise provided in this article, which of course contains the 32 and 33 provisions, which are excluding governmental authority. And in response, I know Justice Jamada sought to summarize my learned friend's submissions by saying, well, you know, what you're really talking about is the underlying activity, which is the provision of insurance services. And we just wanted to point out at paragraph 37 of my learned friend's reply, they say to the extent that government's actions involve the exercise of governmental authority, they did not involve the provision of insurance services. And there's nothing in the OA which talks about this complaint about intervention in the provision of services. This, with respect, is a belated attempt to come up with an answer to the Article 30 position. Unless there's anything else we can assist you with, those are our submissions in reply.
Yes, well, thank you very much, Council. We would naturally take time to consider the and submissions, and in due course, we would let you know.
Thank you very much, Steve.
Much obliged.
Much obliged.
Madam Deputy Registrar, to close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnat-Lee. Thank you, Mr. Justice Burgess. And thank you to Mr. Justice Jamala. Thank you, Council. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.